Dear TMB, it's quite clear that from the information yesterday, I made it clear that the flexible option agreement was missold and misleading, and that it could not comply to the Credit Consumers Act at that time. On researching the internet, we find that the BBC actually on the 18th of December 2012 did an article on this with various mortgage lenders: Northern Rock, HBOS, BOS, Barclays, Lloyds and TMB. So, you were aware of these problems with these agreements, and it says quite clearly the Credit Consumers Act 1974 covers this agreement and lays down the certain requirements for your protection which should have complied when the agreement was made. If they were not, we cannot enforce this agreement without acquitting a court order. You sold Court Farm Cottage that belonged to Pauline Jones. You sold that cottage without a court order on the basis an LPA receiver was party to it. That LPA receiver had no enforceable law to be able to do what he did, and you know as well as I do that they had to have a court order to sell it. So, we claim, and we will be claiming via a private criminal prosecution of the staff that were involved with the recordings we've got, that fraud by false representation, Section 2 of the Fraud Act. A person is in breach of this section if they dishonestly make a false representation and intend by making the representation to make a gain for himself or another, or to cause a loss to another, to expose another to a risk of a loss. That's Section 1. We believe by making a private criminal prosecution, which we will be producing a pack today to go to the court on Monday, that your Mr. Higgins and various other people that have been involved in this case over the last 2 years, while that property was being sold, and at the time of that property being sold, all conversations were recorded by Mr. Brian Jones, and as you can imagine in criminal law, they can be provided. Now we will provide them, we will provide a claim, we will take this claim. This claim is not facetious. Now I know that you have to provide that element of being able to show that it's not facetious, and it is within the public domain. It should be made public on the basis there are other people out there. Well, look at Northern Rock. Just for instance, they've had to cover £270 million because of this. The simple factor is you acted improperly on Court Farm Cottage, regardless of any of the other cases. You acted improperly on that one case. The other element is we believe that an action should be taken for misrepresentation on the basis that you or we relied on the Credit Consumers Act being part of the agreement, and in fact it says it on the signing box that you accept this as part of the agreement. The simple factor is, unlike Brian, I will do what we say, and we will take criminal action. We will ask a judge on Monday to assess whether he will provide us with warrants to serve on the staff that were on duty at that time being recorded. And they sold the property without a court order, without any enforcement of law to be able to do so. This, if not agreed today to have a meeting to talk about settling these arguments and debts of money that you owe us, forget whether we owe you mortgage payments. The simple factor is you owe us nearly £600,000 worth of damage, and I don't believe these contracts are anywhere able to be acted upon on the basis that it was misrepresentation. How can you have a document there saying it's part of the Credit Consumers Act when it's not? If I wrote that document, I could easily be sued for it. It's unfair. We relied on the information on that day of signing. So I ask now that people get their sensible head on and talk. The number again to arrange a meeting is with myself, Duncan Jones, 07901 676 142, or Brian Jones, 07939 206 213. Don't forget, Walker Morris were also involved when the sale of this property was going on. And because Miss Allen was involved, we have recordings of her thoughts on that day. Now, she told me yesterday, quite clearly, and actually 2 days ago on recordings, my client does not need a court order to take your properties back. I'm sorry, but you do. And that was a statement that was wrong. And as far as I'm concerned, you're compounding the fraud that has been caused. This will go further. We will not go down the normal lines. We will go directly to the heart of what's gone on, unless you arrange a meeting to settle the debts outstanding. Have a good day. And Mr. Colcuddy, by the way, you were informed all the way through of this information. You being a lawyer and representation of the head of this department, you would have known that this criteria was going on in 2012. You would have known of the articles on the BBC, and you would have known of the question to the laws of this document. And you would have known that your client didn't act properly in having not had a court order on this one property. So I wonder who the criminal action will be against. Have a good day, and I hope you have a good night's sleep thinking about that, because we lose sleep every day thinking about the destruction you're causing.